talk about today is compulsion, coercion, and the Mental Health Act. So my name is Giles. I'm Associate Professor up in the Department of Psychological Medicine. You will all see me again when you come through sixth year. I'll be your convener for your 4 weeks that you're with us. So normally, obviously, I don't do this over Zoom, and normally I try and make this interactive. So this will be definitely shorter than 2 hours, you'll be pleased to hear, and should cover all of the major bits of information you're going to need to know, both in terms of your 5th year exams, but also in terms of the stuff you'll need to know to think about, I hope, compulsion and coercion. All right, and as you can see, sometimes my internet's a bit unstable, so hopefully this works fine. What I haven't put here is my email address, but if you have any questions or comments or things that are unclear, feel free to just drop me an email and I'll do my best to answer them if you have any questions or queries. So I guess the first thing for us to think about is the fact that we spend 5-6 years, and then we're going to spend a number of years when you're a registrar, trying to instill in you a belief that what you know in medicine is right, that what you know, you definitely know, and that there's very little uncertainty about what you're going to do, or at least when there is uncertainty, the degree of uncertainty is clear. And obviously, that's not the case. An awful lot of what we do in medicine is based on good practice with our evidence, and a lot of the evidence that we might bring to bear on our practice often requires some degree of conceptualization about how we look at it in terms of its generalizability. So I think it's really important when you're practicing that you just bear in mind that every time you see a patient, every time you engage and interact with them, every time you share your expertise with them, the purpose of doing this is for them to then make decisions about what they want to do. And those decisions are often, I'd say, usually in line with what we would think as being the best thing to do for the kind of, man on the Clapham bus, a normal kind of review or perspective. And sometimes when you're seeing patients, you're telling them that they have option A or option B or option C, and we don't really have any good evidence about what might be the best option. So they kind of know that there are some choices. But of course, sometimes we will suggest option A, and we'll strongly think option A is the best option, and a patient might choose option B or C. And of course, then the question is, how do we understand what our limits are? How do we decide what is in this person's best interests? Or should we even be doing that? So that's kind of some of the stuff we're going to think about here. And clearly, if there's an overlay of psychopathology, people have symptoms in the mind, the way they think or understand or interact with the world is very different from the way many of us do. It raises another level of complexity. And that's the sort of stuff that we need to think hard about. So sometimes it's really obvious that some things are just wrong. They're just ethically wrong. They're things we shouldn't do. And it's really clear that they're things we shouldn't do. So these are just some clippings from, they're in the public domain. These are articles talking about cases where doctors have done things that are ethically pretty difficult to justify. Things like sleeping with patients, stealing patients' medicines, threatening to kill a patient. These are actions that clearly fall well outside what can really be justified in almost any circumstance. And in these sorts of situations, it's pretty clear that we shouldn't be doing what we're doing. Once you graduate and become a doctor, you don't stop being a doctor, even when you're not at work. It's important to kind of hold that stuff in mind. Okay, so having had a brief overview of the fact that we're not quite as awesome as we'd like to be all the time, essentially what we're going to do is think a little bit about the ethics that underlie some of this stuff when we think about capacity and consent. We're going to take a look at some of the law in New Zealand and what the law requires us about. We're going to think a little bit about some guidelines, particularly the Health and Disability Commissioner guidelines, and then going to have a think about how we apply that to our day-to-day medical practice. So we'll start off with ethics. So Angela and her team will have already spent quite a considerable amount of time talking to you about this. What we're not going to do is go through the sort of basics of ethics in any particular detail, But it is worth bearing in mind that much of the legislation in British Commonwealth countries like New Zealand is based on some of the early classical philosophy and philosophical beliefs by people like John Stuart Mill. And Mill and his contemporaries, as well as being philosophers, were deeply embedded in the political system and helped to build up the political system and the judicial system within which we work. So I guess this is a very strong view of Mill and many others, and in fact is a view that's reflected in our legislation, which essentially says, as an individual within society, you can do whatever you like, so long as whatever you want to do doesn't impact on others. And I guess that's a really important basic tenet in medicine that's been conceptualized as autonomy. And the way autonomy is operationalized, the way we see it working, is in the delivery of consent for an intervention by a patient. So that's a patient making autonomous free choice. And so this is how that kind of looks. And you guys kind of know about this. So everyone's pretty well clued up on the four basic concepts of principalism, and in their most recent edition, they've added this fifth element, the doctor-patient relationship, which helps to understand that there is something interactive here, something relational, which is really important when we think about how these principles work. The other thing Beecham and Childress talk about, but we tend to gloss over, is this notion of specificity. So specificity is the idea that what you do is you take the various facts, and with those facts, you specify how the principles will work. And some people have critiqued this because they don't like the idea of essentially massaging these principles to fit what you want to happen. But this is kind of how they look at this. Importantly too, Beecham and Childress talk about principalism as being pluralist. It's not based off a single philosophical theory, which they are then trying to implement. Instead, what they've done is to take a kind of a normative view. This is kind of what we see, almost this is the folk philosophy there is, and have tried to operationalize that in a bioethical way into these principles. Over time, it's really clear that autonomy has kind of become the king. When we think about capacity and consent, it's important to bear in mind that, like it or not, autonomy is the principle which tends to carry the greatest weight. Okay, so how does that look in terms of law in New Zealand? Well, I think it's important to bear in mind that in New Zealand, we have a strong human rights principle. What we don't have is an underlying charter or bill of rights that are our founding documents. Instead, what we have is human rights principles, and then those are articulated in BORA, the Bill of Rights Act. So this isn't supreme legislation like it might be in, say, the United States, but this is how legislation in New Zealand is developed. So we have a whole series of statutory requirements that exist in law, but that then becomes interpreted over time through various cases as they occur. And there tends to be a strong human rights influence as to how this legislation is reviewed. And so this is actually a slide from Professor John Dawson, who's a professor of law down in the mothership in Dunedin. And so when it comes to practice in medicine, there are a number of laws which are of particular importance. And so I just kind of listed these here. So the first one there, Macat, is the Mental Health Act. Then we have the Criminal Justice Act, the Impaired Persons Act, the Intellectual Disability Act, the Triple PR Act, which you're going to come across a lot, and then a common law of duty of care that we talk about. And more recently, we've now got the SAC Act, which is a Substance Abuse Act, which in essence is a mirror of our Mental Health Act, albeit specifically for people with substance abuse problems, which are explicitly excluded from the Mental Health Act. So these are the three where we all need to know about these. You need to know about these as a junior doctor, and you need to know kind of how they're used and how they're applied. So where we've talked about the Mental Health Act and SAC Act are specifically related to legislation related to trying to support people who are considered not to be expressing their authentic self, and those failures to express some sort of authentic self or their own genuine autonomous view are considered to be related to mental illness, Mental Health Act, or substance dependence, Substance Abuse Act. The PPPR Act takes quite a different view, and here the PPPR Act looks at people who have any disorder of mind which leads to a permanent impairment in their capacity to make decisions. And in those cases, the PPPRA then provides for others to substitute the decision-making capacity they have. And so this is quite a different approach to both Mahat and Sahat. And from a kind of a practical perspective, this really comes out from where they're developed from. So both the Mental Health Act and the Substance Abuse Act have been developed out of the Ministry of Health, and the PPPRA is developed out of Justice, the Ministry of Justice. And so the people who have written these acts have thought about these, and the policies behind them are actually in two quite different places in government, which in part explains why they actually look quite different. Importantly, when we introduce legislation in New Zealand, it sometimes is related to our international obligations. And so the United Nations, about 15 years ago now, introduced this, the Convention on the Rights of Persons with Disabilities. Importantly, the CRPD provides no new rights for persons with disabilities. These are the same rights that are enshrined in other United Nations conventions around respect for persons and autonomy. However, it was realised that there was a great deal of concern internationally that people with disabilities, that includes people with mental health problems, or as the CRPD committee like to put it, people with psychosocial disability, weren't having their rights, weren't having their autonomies actualised. And so the purpose of the CRPD is to try and support that to happen. So what the CRPD does is it places a requirement on governments who sign up to this, and New Zealand signed up to this in 2008, to amend their legislation in order to bring it in line with the principles as outlined in the CRPD. It's absolutely clear, because the CRPD committee has been to New Zealand, that at the current time our mental health and by implication our substance abuse legislation is woefully out of line with the CRPD. And indeed, TRI, the mental health inquiry a couple of years ago, would suggest that one of the key priorities, our government has accepted this, is to repeal and replace the Mental Health Act. And my understanding is work is supposedly being done on that at the moment. So this is a space where you're going to learn a bunch of stuff now, but quite likely by the time you're practicing, there'll be some modification to it. And then probably over the next 5 to 10 years, there'll be some quite significant legislative change in terms of what it means to provide a substitute decision maker, whether that be through a mental health or substance abuse type legislation, or whether that be through PPPRA. And so I guess this is a kind of a heads up that this is coming. It's also important, and this is in case now, is that you're aware of our code of practice principles. So these are the kind of basic minimum requirements of the way that we are supposed to be practicing at the current time. Nothing on this slide is going to surprise any of you. And indeed, all of this is kind of common sense, if you like. We would expect all of this to be in place. I do think it's interesting to notice that this not only has a strong emphasis on individual autonomy, but does place some sort of overarching justice, ethical principles on us as well. And this is about, for example, how we use the resources we have, how we distribute the resources we have, and how we make sure that not only the patients in front of us, but the many patients who we haven't seen or are being seen by others are able to access healthcare in a reasonable way. And whenever you work within a public healthcare system with restraints on it, like ours, it's important to be mindful of the fact our individual choices will impact on how other people are able to access healthcare. And so that clearly makes a difference when we think about these things. One of the ways that we are individually regulated here is under the Health and Disability Commissioner. And so the Health and Disability Commissioner has a particular mental health commissioner, but also the HDC runs its own process. So something that happened post the Cartwright inquiry was the development of the HDC, whose role it is essentially oversight. So the HDC suggests that patients have certain rights, and when patients have certain rights, that means others, in this case doctors, have certain responsibilities. So the HDC is very clearly written in a way that suggests we as doctors have responsibilities to our patients, and they have the rights to see those delivered. And if they are not, then the HDC can enforce some kind of reparation or reprimand because of it. So these are the three rights that are thought about most commonly in everyday practice: the right to effective communication, the right to be fully informed, and the right to make a fully informed choice. And by doing that, by give consent. So consenting to something and being fully informed about something are two separate processes. The HDC process is an important one, mostly because it provides overview. I guess my experience working clinically now for over 20 years would be that sometimes we become quite individually anxious about the process of overview by someone like the HDC. HDC are mostly interested in systems problems. I mean, if a doctor is grossly negligent, they will pass those concerns on to the New Zealand Medical Council. But HDC is generally looking at systems problems in a way to make sure those systems problems don't continue over and over. So I've been involved, for example, in HDC reviews where it's very clear that an individual doctor has done something unwise, but almost invariably that unwise choice has happened within a system which has made it at least understandable how that has occurred. And as a general rule, HDC is looking at systems, not individuals. So what do they mean when they talk about consent? Yep. So essentially, it's important to kind of hold some things in mind about consent. All right, and this slide you do need to know about. This slide could be in your exams. So consent is in New Zealand is considered cross-sectionally, and it's considered specific. So for example, someone might be considered impaired in their capacity to consent for a very technical surgical procedure, whilst at the same time clearly not be impaired in their capacity to consent about their choice of dinner. So it's specific both in time, but it's also specific in terms of context. And certainly when it comes to identifying what you should be doing, it is these four things. You need to be able to understand and retain the information, believe the information. They say appreciation of the options available, or to weigh your choices in the balance, and then to communicate that choice. Sometimes people talk about that choice needing to be communicated consistently. But of course, as soon as those sorts of elements are brought into this, it immediately stops it being a cross-sectional assessment, because people can only do something consistently across time. And so it's important to kind of hold these elements in mind. There are some direct spin-offs of these. So you can see you have to actually be able to deliver the information. You need to actually be able to be sure that a person is understanding and retaining it. You need some conceptualization of belief, and you need to be able to weigh options. So you need to know that a patient is thinking this stuff through. And so when it comes to considerations about the capacity to consent, it only ever can really be an expert or somebody who is knowledgeable in the intervention that is being suggested who can do this. Although there may be times when other individuals, so for example, a psychiatrist, might be helpful in terms of conceptualizing whether the mental processes to do some of these things are occurring. So to put that into real terms, I can't consent someone for a complicated surgical procedure because that's not what I do. That would require a surgeon who does this complicated surgical procedure to do that. What I might be able to do is assist that surgeon in thinking about whether a patient is doing these mental processes. But I certainly, this sort of consent can't occur except by somebody who knows what they're doing in terms of the particular operation itself. Really importantly, having a mental illness, even with active psychopathology. So for example, so having a diagnosis of schizophrenia and experiencing some symptoms of schizophrenia does not mean that you're incompetent to make choices. So these elements have been operationalized into metrics that we can then use to measure people's relative capacity to consent. You can argue about the philosophical basis of that, but this has occurred. People have then used those metrics to assess, for example, whether patients with schizophrenia who have active psychopathology, hallucinations and delusions have the capacity to consent to treatment decisions, whether they should be taking medicine or not. And between 60 and 80%, depending on which studies you read, of people with schizophrenia do have the capacity to do that. So that's an exemplar of how sometimes we'll sit there and think, I don't know if this person has capacity, and we might have a default view that we think that that is unlikely. So we might think that somebody with a really serious mental illness like schizophrenia might be considered to have impaired capacity. And as soon as we discover that they have some active psychopathology, we might immediately think, well, they're clearly not going to be able to make some decisions, so we have to do that for them. But actually, the best evidence that we have would suggest that for most people, most of the time, that is not the case. Actually, what the CRPD and some human rights writing would suggest is that that should never be the case. We should never be thinking about individuals as lacking capacity. Instead, we should be thinking about individuals as having their capacity needed to be supported. And indeed, the CRPD would argue that people with mental illness should never have their capacity to consent substituted by somebody else. And that is exactly what the Mental Health Act, the Substance Abuse Act, and the PPR Act do, is they provide for essentially a substitute decision maker. So we might come back to that, and that is important to realise that there is a growing parallel argument here that would suggest some of the foundational principles of the way that we understand this sort of consent in medicine, but also the legal basis of some of this sort of consent is fundamentally wrong. And that growing group of people are increasingly arguing for this sort of assessment to not happen altogether. Although at the current time, that is not playing out in medicine. So again, this might be quite a major change to the way we practice. That will occur relatively early in the course of your careers. It's difficult to see exactly where that will go. So it is important that you're able to formally understand the elements that are currently required of consent. So you can see here, this is cross-sectional. To say that again, this requires you as the doctor to make some judgments about your patient in these 4 domains. And by doing that, then you're making some sort of judgment about their ability, their capacity, or competence to consent. So you're going to come across these words, capacity, competence, rah-de-rah. These tend to be used interchangeably in the literature. Some jurisdictions have specific meanings for them. So for example, capacity might be something a doctor assesses in a patient, and competence is something that a lawyer will look for at law. But as a general rule of thumb, I'd consider these interchangeable in terms of the way that you should think about them. So what does this mean for you? What's your duty of care here? Well, these are some of the things that I would encourage you to think about when you think about what your duty of care is. So as you can see, that there's lots of ways of thinking about duty of care. So when we do this, not online, I talk through a case at this point. And rather than talk through a case, what I'd encourage you to do is think about what your duty of care is to your patients as you go. So I know that you do this in other parts of your ethics stream. And I do think it's important that you think about where the limits of your duty of care is, what our legislation and our community requires of us, and how much of that you're comfortable or uncomfortable with. Different doctors will have different conceptualizations of a duty of care, but all doctors are regulated by our normative values, and they're enshrined by things like the HDC, which is why it's important to know those basics. So you want to be thinking about this sort of stuff if you're worried about someone's psychopathology or capacity in relation to mental health, then something you do need to think about, and something you definitely need to know about both for your exams, but as you move into clinical practice, is the Mental Health Act. So mental health legislation has been in place in New Zealand now for over 4 decades. And indeed, mental health legislation is common all over the world. As you can see, it's much more common in some parts of the world, but in parts of the world where mental health legislation hasn't been enacted, they tend to be working pretty quickly to build some of that legislation up. So what you have here is a system at law which allows doctors, and sometimes those doctors have to be specialists, but allows doctors to do things to other patients that presumably they wouldn't consent to do, or you wouldn't need the legislation on the basis of some kind of a mental illness. So that's the kind of basis for this. Now, if you think about it, we don't have legislation that enables doctors to do stuff to other people in any other part of medicine. And again, I'd encourage you to have a think about what is it about mental illness that makes that different? Is it just because people act strangely? Is it because people make choices that we're uncomfortable about? Is it because we think people aren't really expressing their authentic selves when they are making or expressing a choice to us, and that requires us to think about their normal, authentic self or not? So they're the sorts of questions I'd encourage you to think about when you have a think about mental health legislation and how that works and is operationalised. And we're going to talk a little bit about our mental health legislation in a minute, which is built off the British Mental Health Act. So these are built out of these legal conceptions. But also it's important to bear in mind that there are some parts of the community that think all mental health legislation essentially shouldn't exist, or should exist in a radically different way than exists currently. And so there's this interesting kind of balance and counterbalance that's going on at the moment with various parts of the world trying to catch up by writing and enacting mental health legislation. And in parts of the world like New Zealand, where it's very well embedded, are growing parts of the community calling either for abolition of mental health legislation completely or for a radical revision of it. And so what is New Zealand's Mental Health Act? Well, it's this thing here. It came into being in 1992. So it's been around for a long time and has undergone some changes over time. So some amendments, and again, that's very common for legislation. So the legal writings around mental health legislation would suggest that every 2 or 3 decades, this legislation should be up for review. In other words, we should either be looking for major amendments or looking to repeal and replace this sort of legislation. And that time frame is related to how our society changes. And this legislation, of course, is really based on what society thinks, as well as how we understand mental illness. So importantly, back in 2000, I think it was 2009, there were some important amendments about this mandatory family whānau consultation. And this was really built in because a lot of people were being detained under mental health legislation, particularly Māori, without consultation with family, and it was causing a great deal of division and difficulty. And so this was built in to try and protect and include family into treatment for mental health problems. So what does it do? Well, it outlines some circumstances around which compulsory assessment and treatment can occur. What it's supposed to do is enhance the rights of the people subjected to any sort of compulsive, and the overlining principle here is one of a least restrictive environment. So in terms of the circumstances of compulsory assessment, in our legislation, all it really requires is an assessment of mental illness, which can be continuous or intermittent, and risk. And that can be to self or to others. So already you can see that there's pretty loose legislative terminology. So if you believe the epidemiology, something like 1 in 5 New Zealanders will have a mental health problem which would benefit from intervention at some point. Mental health legislation requires you to have a mental illness that can be intermittent in nature. So immediately, at bare minimum, 1 in 5 New Zealanders fulfill the first limb of the Act. The second thing you'll notice is it doesn't define what it constitutes as a risk. Now, sometimes people make a default to low incidence, high risk, or high poor outcome types of problems as being what that Act means as risk. And we all think of suicide and homicide in those terms, right? So what's the risk that someone's going to hurt themselves or kill themselves and or hurt or kill someone else? Now, actually, these behaviours are very low incident, so they don't occur very often. So they're low incident behaviours, but with obviously a very high outcome in terms of harm. And so they tend to preoccupy our minds. However, trying to predict those sorts of outcomes is very, very difficult. So being sure about knowing what we're doing in terms of risk in that regard is very difficult. Risk can also be considered about much more common, so high incident behaviours, but with actually relatively low outcomes in terms of harms. So for example, there it might be, is someone keeping their house clean, keeping themselves clean and eating adequately? And you can see there that that is far, far more common, that mental illness might impair those functions. But then it kind of raises a risk of, well, how much of that do you need before it genuinely constitutes a risk? So lots of people in society choose to live in ways that we might think of as being, not eating very well and not keeping yourself in a state of cleanliness. But they're making choices about how they choose to live, and we consider that to be okay. So it becomes more difficult not in terms of the outcomes here, but in terms of judging whether this genuinely constitutes risk. And obviously what we're trying to do here is provide some sort of rights for people. So if you are going to be detained, have your rights taken away, then what the Act tries to do is ensure you have some good, safe, legal safeguards. So these are mechanisms to appeal about what is going on. And the idea here is to enhance the rights of whoever is subjected to this sort of compulsion. And the overarching principle here is to be least restrictive. So again, if you think of that quote from John Stuart Mill earlier, this is trying to reinforce and make really specific that what we should be trying to do is just allow people to get on with their lives, so long as that's not impairing others at the same time. And so on the face of it, at least, this mental health legislation is very kind of pro autonomy and liberty. All right, so let's look at it. Who gets to use the Mental Health Act? Well, so medical practitioners use the Mental Health Act, and that will be you guys and me. So in terms of how the Mental Health Act works, any person can start the process of the Mental Health Act. So anyone can complete a Section 8A, and it's simply saying, I'm concerned about somebody who has a mental illness. Then you need a medical practitioner to complete the next part of the assessment process, that's an 8B. And that can be any medical practitioner. That doesn't need to be a psychiatrist, but it does need to be somebody who's fully registered, not provisionally registered. So what that medical practitioner is saying, that will be you guys after you've got your general registration, is saying, I agree. I think that I am concerned about this person in terms of their mental well-being. I think they might have a mental health problem, and I think there are some risks here. What I need is a specialist and expert to see this person to continue this assessment. And so this is kind of rolling the process on. So at that point, someone starts to lose their autonomy. They might not want to have a further assessment, but at this point, legally, they have no choice. So we've started to restrict people's autonomous choices. We've started to override their decision-making. And interestingly, we've done this without any formal requirement to assess their capacity. They may be fully capacitous to refuse further assessment, but actually legally now they're obliged to engage in the process, or at least have this occur. And so I do think it's worthwhile emphasising this pretty pretty, quite strong powers that you have here in terms of what you can oblige people to do. So then we have a duly authorised officer. So the purpose of a duly authorised officer at DAO is to make sure that the steps of the act occur appropriately at law. So this is kind of recognising that someone's having their rights restricted. And if we're going to do that, and that is serious, there needs to be somebody who's not part of the assessment process, who's making sure that these rights and that the processes of the act are occurring. So if someone is detained under an HB, an 8B, then those bits of paperwork are given to a duly authorised officer. Their job is to watch the process, monitor the process, and essentially make sure that the person who is being assessed understands their rights according to mental health legislation. So they're a really important part of the job. Often it can slow down the assessment process, and it can be frustrating for people because people, for example, if they're in ED, they're pretty keen for things to keep moving and for a medical assessment to occur, but it requires a duly authorised officer to monitor the process. I mean, that's a legal requirement. And then you have the responsible clinician. So a responsible clinician is a psychiatrist almost always who comes in to undertake this kind of first formal assessment after the medical practitioner has. The way the Act is written is they say the responsible clinician should be appointed to see somebody as soon as appropriate, and it should be somebody who's sufficiently senior in recognition of the fact that what we're doing here is pretty significant. We're taking away someone's right to make choices about their own health, and potentially we're going to substitute that with choices made by somebody who may not know the person other than in a purely medical and sometimes not for very long capacity, i.e. a responsible clinician. So they really need to know their stuff. In most places, that will be a consultant psychiatrist. Sometimes others are licensed to do that. So when I returned to New Zealand in 2007 and moved to the Hawke's Bay, there are a number of general practitioners with special interest in mental illness who were authorised as to be able to engage in assessments. And so they couldn't be a responsible clinician long-term, but could undertake a first assessment of someone. So that assessment occurs, and then a responsible clinician is assigned for the first period of assessment, and that can be for up to 5 days. So you come into ED, and 8A is completed by a member of public, someone's brought into ED or prison, the hospital, police station. The duly authorised officer receives the 8A and an 8B from any medical practitioner. That might be a medical practitioner in ED, or might be a psychiatric registrar if they're in, say, the police station, and then somebody who could be a responsible clinician, so that's generally a consultant psychiatrist, will come and see the person and say, yes, I think this person needs a first period of assessment that can be for up to 5 days. And the person generally then will be referred to hospital where that occurs. The Act actually allows that to occur in the community, although that very rarely happens. Now, once someone ends up in hospital, generally, then there are a variety of assessment processes that can occur under the Act, and this includes providing someone with pharmacotherapy and occasionally providing somebody with restrictions in their movement, and potentially even seclusion. So these are some fairly large powers that come to bear on someone and can occur. And because of that, each area of New Zealand has a director of area mental health service. This is generally a senior clinician. Commonly it is a consultant psychiatrist, but not always, who receives the paperwork of everybody who's been detained. And their job is to kind of overview this from a process, to read the paperwork, make sure that each decision to detain somebody has been properly articulated and is justifiable, and that the general process in terms of managing the systems are in place, so that there are appropriate people to collect the paperwork, to manage patients, that there are independent lawyers who are able to come in and support people, and those sorts of things. So it's a relatively time-consuming job and is required. And then directors of area mental health services, DAMS, then report to the Director General of Mental Health. Now, many patients obviously don't like being detained, and the Act provides for those people to have their decisions reviewed. And those reviews can occur either in the family court, although that generally occurs in the hospital, but the room in which it occurs for becomes a family courtroom temporarily. So they're reviewed by a judge, or they get reviewed by the Mental Health Review Tribunal. Now, the Review Tribunal is made up of 3 people, an expert, a layperson, and usually a magistrate of some description. And their job is to overview someone's treatment under detention and make a decision about whether it's appropriate from a legal perspective rather than a medical perspective. Yeah. All of these processes obviously specifically relate to the Mental Health Act. And because of that, district inspectors, these are lawyers, are engaged. District inspectors have the right to come into hospitals to see patients' notes, to talk to patients and to understand the process of what has occurred. Now, what district inspectors are doing is trying to make sure that we are acting when someone is detained in a legal fashion. Even the Mental Health Act is open to interpretation. District inspectors trying to work with mental health services to ensure that what is occurring is legal and as is designed to occur in the Act. We also have official visitors. Official visitors are people who are legally allowed to enter hospitals and monitor the processes. And again, these come from various parts of the government. And finally, keeping an eye on all of this is the Director General of Mental Health. At the moment, that's Dr. John Crawshaw, based at the Ministry of Health in Wellington. They receive all this paperwork as well as a wide variety of other paperwork, and again are responsible overall for collating this information and ensuring the system is running equitably and smoothly across New Zealand. And they do this essentially by relating to the dams and district inspectors and collating an annual report. So that's who. Now let's look just a little bit more closely at those processes I've talked about. Again, I think you need to know this stuff from an exam perspective, and you definitely need to know about it from being a doctor perspective. So anyone can do a Section 8A, anyone over 18, so any adult. You need to have seen the patient within 3 days. So the person you're worried about needs to be someone you've seen. You can't say, I'm worried about Daisy, who lives in Auckland, who I spoke to 6 months ago. Need to have seen them, within 3 days. You can be related, that's okay. So what you need to do is complete the Section 8A, and then you need to hand it over to a duly authorised officer. What they will then do is get a doctor, that's you guys, to see somebody, and their job is to assess someone and make a decision about whether to issue an 8B or not. And as we've said, an 8B is really just your medical view about whether someone might have a mental illness and might be at risk. And obviously, the levels of expertise are going to vary quite dramatically amongst medical practitioners. You just have to do the best you can with your range of knowledge and expertise, which will be exponentially greater than for the general public. They then come to a psychiatrist, almost always a psychiatrist, doesn't have to be, who undertake an assessment. And that assessment is designated under Section 10 of the Act. But what actually happens if someone is going to be detained is then Section 11 occurs. Now, this is a 5-day assessment and treatment period. So one assessment, 2 bits of paperwork, a 10 and 11, or one piece of paperwork, a 10, which then stops the Act. And that's the end of the process. So both of those things occur. But you don't do a Section 10 assessment and then a separate Section 11 assessment. They're rolled just together. So when someone's detained under Section 11, it might be in the community, but it's almost always in a mental health ward. And they're there for 5 days. And that is primarily for assessment, but treatment can occur as part of that assessment. If after 5 days, the team still have serious concerns and do not think that the period has been long enough, they then can apply for further assessment. And so you can see here that this is quite some time. Yep, so a further 14 days, so that's 19 days, and then a further 14 days, that's 33 days. You're in hospital against your will, presumably not wanting to be there, potentially for up to a month. Now, you do have the opportunity for legal redress. So patients can apply for appeal under Section 16 of the Act that allows them more immediate access to a judge. And those periods of time, eventually what happens then finally will be a final assessment. Yep. And a final assessment means that someone's either going to be assessed for longer in hospital or in the community, at which point they need to go to court. So fundamentally, if someone is going to be detained under the Mental Health Act beyond this initial period of assessment, it's not actually a psychiatrist who makes that decision, it's a judge. And so patients come to the family court, and in the family court, either an inpatient or an outpatient order is made. So if it's an inpatient order at section 30, if it's an outpatient order at section 29, what that means is that this person is now detained for 6 months. So they're detained under the Mental Health Act, and the responsible clinician, generally a consultant psychiatrist, then has a wide range of powers that the Act provides for them. So they're provided for by a family court judge, and like I've said, that normally occurs in a room designated as the courtroom rather than trolleying down to the district court and wherever you are. So after a period of assessment in the community, the final part of this is something called an indefinite order. So 2 6-month orders are applied for, the patient is detained for a year, and then at the current time, judges can then make an indefinite order. What this means is this person, as it suggests, can be detained under the Mental Health Act without judicial review forever. So when you think about that, it's pretty serious. You could be 18, have your first psychotic episode, be detained under the Mental Health Act, let's say, come into hospital, get discharged, come off the Act, become unwell again, get detained again, come into a mental health hospital, now be placed on an outpatient order, so you're detained in the community, that be renewed twice and then placed on an indefinite order. So you could be age 20 and have your rights to make choices about your health and well-being, about what you do in terms of your health and well-being taken out of your hands. And if you choose not to agree with what goes on, then a responsible clinician like me could call the police to enter your property, could call the police and have you brought into hospital against your will, obviously. I could direct the level of care at which you live. So if I say you need lots of support, that means you might not be able to live independently. There are wide-ranging powers, and those are powers with no longer with judicial oversight once they've been provided indefinitely. And unsurprisingly, particularly the committee of the CRPD, but many others think that this is wildly out of order, that these indefinite orders should exist. Certainly, the Ministry of Health recently have emphasised the least restrictive environment overview that we've already talked about. And so although these powers do exist, they encourage an onus on psychiatrists, responsible clinicians, to look to take people off the Act, although that is not always the way the judiciary sees this. And so there's a balance here between what the courts do in terms of understanding New Zealand society and what doctors do in terms of understanding their duties and responsibilities in terms of how the Mental Health Act works. My slides seem to have got stuck. Oh dear, hang on a second, apologies for this. All right, so let's just very briefly zip through some other parts of the Act. I do think you do need to know about these as you move on, but I don't think you need to know about these in a huge amount of detail. So essentially, there are parts of the Act that give powers to various parts of society, which means that the way they act is not illegal. So, you know, if I was just to choose to go and scoop somebody up and restrain them, I'm actually assaulting them. And so I'm only allowed to do that if there are some particular reasons for doing that. So Section 109 gives the police powers for the period of 24 hours to essentially intervene in someone. When you were given, as a medical practitioner, powers to see someone and require an urgent examination. Section 113 gives people the right to call the police and the police to then engage Section 111 is one that you will come across, and sometimes as PGY1s, PGY2s, you might get called to see somebody in hospital. You might be concerned about an acute deterioration and think that you need to intervene in a way that is going to keep somebody safe, but you don't think you can just do this without under your duty of care, which you might be able to do. Now, what you can't actually do is restrain them in hospital, but what you can do is advise the nurses that they can use Section 111 of the Mental Health Act, and that allows registered nurses who are caring for a hospital patient to detain them in hospital for up to 6 hours. So it gives you a little bit of breathing room. Now, this is most commonly used in mental health on mental health wards, but there will be times when patients with acute mental illness are in medical wards. Very occasionally, I've seen this used, for example, for somebody who had alcoholic liver disease and developed a fairly rapid encephalopathy. I've seen this used for people with non-suicidal self-injury, so people who have hurt themselves and are on a medical ward and are making what we might be concerned as very junior members of staff to be really unwise decisions. And you just need some breathing space to get someone more senior to see them without them leaving. And in these sorts of situations, it might be that Section 111 is the most appropriate way of detaining somebody in hospital. Now, that's not something you can do as doctors, but that is something you can discuss with usually a charge nurse or clinical nurse specialist, nurse practitioner, and that nurses can do. So it's actually a really important part of it. There's always a right of appeal for doing this. Any of these and any of this sort of detention, so this isn't a right of appeal for Section 111. No court's going to get itself together in less than 6 hours to look at this, but I mean, it's actually for any section which reduces people's liberties. And when that occurs, you just get the same sort of thing that you get in any court. You go to court, you make your case as to why someone has been detained. The patient makes a case as to why they don't think they should be detained, and sometimes that's with legal representations. They get a lawyer. And certainly they're entitled to a lawyer free in many situations. And then a judge makes a decision. And if you don't like that decision, then you can appeal it. And if you don't like the appeal, then you can go to a review tribunal. And if you don't like the review tribunal, you can make a claim of habeas corpus. So that's unfair imprisonment. Or a judicial review, and that's to say that the law here is not being applied right and the law needs to change. So that's these things here are always legal mechanisms to protect someone's liberties. That's what the law is essentially doing here, is saying we recognize this is a serious power we're giving doctors. The serious power is to restrict people's autonomies and physical freedoms, and because of that, there are lots of legal avenues to pursue to prevent those being abused. Even with all of this sort of legal support, many people still don't think any of this is sufficient, and actually think the only real way of taking this forward is either to repeal and replace or abolish mental health legislation completely. So as you can see, there are lots of ways that the Mental Health Act is trying to protect patients. So as you can see here, there's lots and lots of rights patients have. And clearly, it's important that those rights are understood by patients and actually have access to them if they need them. And part of the job of the duly authorised officer is to make sure that happens. Part of the reason district inspectors are appointed and come regularly is to make sure that these rights are being allowed to occur from patients. It's not unsurprising that from time to time, these call into question some of the basis of what's going on. So what's happening and how this happens. Very rarely there are cases when actually more than one opinion, that of the responsible clinician, is required for an intervention. And so that's when we deliver ECT to someone, or in the cases of psychosurgery. And I guess what the law is recognising here are that these are considered from a population perspective to be particularly invasive. And because of that, there's a whole extra level of protection for patients. And that's how that is built. Okay, so They're the various bits of the Act. So the ones you really need to remember are those beginning ones, 8A, 8B, 10, 11, 12, 13, 14, N111. It's important to realise that when we detain someone under the Mental Health Act, what we're not doing is detaining them on the basis of a mental illness. We're detaining them on the basis of them being mentally disordered. Now, that is a legal term that we are applying as medical staff to people. Okay, and so what is it? Well, what it requires is an abnormal state of mind. So that's the mental illness bit. So that's something which either needs to be continuous or intermittent. So you don't actually have to be really unwell. You don't have to be showing their psychopathology at the time, because it can be intermittent. And these are the areas which it can be in. It can be in mood, perception, cognition, volition. So you can see that covers quite a range of mental processes. And it needs to pose this serious risk to health or safety, or to seriously diminish the capacity of that person to care for themselves. So these are risks, like we talked about before, poor outcome, low incident stuff, suicide, homicide, a much higher incident, lower risk behaviours, unable to care for self. And people argue over time about what constitutes this, what makes up this threshold. There is no bounding to any of this stuff. So there's no hard endpoint to any of this. And as you're going to discover as you go on in medicine, the hard endpoints we'd like there to be in many cases don't actually occur. Because of this lack of hard endpoints, because there are judgments in this, there are some specific exclusions that have been written in here, and here they are. So you can see that substance abuse is one of these, and because of that and concerns related to addiction, we now have the Substance Abuse Act, which is essentially the Mental Health Act specifically related to addiction. And what we can't do is use the mental health legislation for any of these other reasons. Okay, every talk has an unreadable slide. And I guess I put this in to really just emphasize what being detained allows a responsible clinician to do. So don't worry about reading it too much. Look at this, okay? So as a patient you are, and I'm going to quote it here, we're required to accept such treatment for mental disorder as the responsible clinician directs. So I can tell you what you must accept. It doesn't say just about medicine, it says treatment. It's about what I think is best. Yep. And that under this act, I can do this without the patient's consent. So it's specific. I can just do what I think is best. And hopefully you're able to reflect that there might potentially be some serious problems with that, because essentially what it's doing is it's substituting a person's decision-making with my decision-making, and nowhere in the act does it make any comment or any reference to capacity. So someone might be completely capacitous to make their own choices, and the act still enables me to substitute their decision-making. And hopefully that makes some of you deeply uncomfortable, like it makes me deeply uncomfortable. But that is the reality of the way the act is written. At its most basic level, that problem, the requirement or capacity to intervene despite someone having capacity, is one of the major concerns that has come out of reviews of mental health legislation in New Zealand and internationally. And despite these concerns, what this slide shows you is that rates of community treatment orders here, so this is being detained in the community, are high. So you can see here we are, New Zealand. Back in 2003, we had a rate of 84 per 100,000. Now we're over 100,000. So if you think about it, 1 in 1,000 New Zealanders is detained under a community treatment order. It's amazing. 1 in 158 Māori men are detained under a community treatment order. It's hard to wrap your head around how common this actually is. Also concerningly, and people have talked about this, if you look at rates of community treatment orders over time, they invariably grow. So in every jurisdiction, I know of no jurisdiction where this isn't the case, Once mental health legislation exists and it allows detention of people in the community, those rates steadily increase over time. And there is a problem, right? But in some ways, it's not that surprising. If someone has the capacity to do something and you give them a lever to do something and they're the expert in doing something, then you kind of expect them to pull the lever. And so simply by having this legislation, it then becomes almost inevitable that it will not only be used, but used a bit more and a bit more and a bit more over time. And I think quite reasonably that does concern a number of medical staff and a significant proportion of the community. So what does it allow us to do? So we've kind of thought about this a little bit already, but this really spells it out. And again, this is another slide of Professor Dawson's, so I'm indebted to him. So we just go through these one by one. So the patient must accept treatment, and that almost always includes pharmacology of some description, but may also include things like engagement in case management, engagement with other areas, sectors of the community. The patient has to come to their appointments, and I am allowed to come onto their property to assess them and or treat them. So again, you know, I'm not just going to let any old Joe onto my property, but if you're detained under the Mental Health Act, you have no choice in the matter. It allows, I love the term, swift recall. So if I'm concerned about you, what I can't do is jump on you in the community to treat you, but I can call the police and have you returned to hospital. And so, you know, you might have police showing up at your door with your neighbours around, scooping you up and taking you into hospital. So, and I mean, they're not, as I've noted here, you can treat without consent, but it has to be in hospital or a properly staffed clinic. So these powers are wide-ranging, and I guess that's the point to note. All right, so the things to remember. So the Mental Health Act is generally thought about as a clinical tool. And people talk about safety, and safety should be a priority, as should being least restrictive. And this is a legal tool, not a medical tool. So when we think about a mental disorder, you're not thinking about being mentally disordered. You're not thinking about mental illness. You're thinking about one of those four domains of psychopathology and risk. Certainly early in the process, all you need are reasonable grounds. So if you're called to assess someone for an 8B, all you need are reasonable grounds. And this is reasonable grounds to whatever your level of expertise is. I teach first-year registrars in general practice. I can tell you in a group of 20, there'll be some people there who will have done 6 months or a year of psychiatry as a doctor, and other people who have done 4 weeks in med school, and that's it. So there is a really broad range in terms of what your expertise, and you just have to do the best you can with what you know. They don't say it in the Act, but I'd encourage you to leave the difficult calls to the specialists. So if it all goes wrong, we're the ones who will have to wear it. And if you're not sure, so you see someone and you're not sure, call the DAO. The process has started. A DAO looks after the process of the Mental Health Act legislation right from the preparation of an 8A being assigned. So if you're not sure, ask a DAO. They're very experienced. They'll likely know what to do. In the Mental Health Act, the Ministry of Health has a guide that can be used as a reference. That guide was updated in December of last year, and those updates are really to try and emphasise the least restrictive elements of the Act and to emphasise that we should be listening to people who have capacity, although that isn't written anywhere in the Act. But again, that's probably if you're in ED or on a medical ward and things are busy, not something you're going to do, but picking up the phone and calling a DAO is quick and easy. Just give you a minute to read this. Okay. And what this says is we need to be careful about our prejudices. And I touched on this right at the very beginning. We tend to think that if you have a mental illness, yep, you're going to be dangerous. and so you're going to be risky. Yeah. But actually, it's a small link, and certainly shouldn't be a normative position. Part of the reason for that might be this. Right? We tend to have a position in society where we highlight the links between mental illness and dangerousness. And what we're probably doing here is stigmatizing patients in psychosocial distress. And so again, I'd encourage you to be mindful of your own position about that. So I think that's it in terms of thinking about the Mental Health Act, but I encourage you to think really hard about that. And an interesting thought experiment for you might be to think about, what would a Diabetes Act look like? Because unlike with mental illness, right, if you have severe diabetes and you're really poor at taking your medicine, you're far more linearly likely to become sick than in, say, schizophrenia. And you're far more likely to be a harm to yourself because there are some hard outcomes, right? Like neuropathy, loss of vision, loss of kidney function, that are clearly going to happen, hypoglycemic crises, death, if you're not managing your diabetes well. So, that can have really serious and much more predictably serious outcomes than many mental illnesses. And you're going to use a lot of community resource if you need to go onto dialysis, if you need home help all the time because of your neuropathy, whatever it might be. So arguably, for someone with diabetes, for example, we have a much more clearly defined disorder and a much more clearly defined set of risks, both to the individual and society. But can you imagine what it would look like if someone tried to bring in the Diabetes Act, which said that if you didn't take your medicine regularly, I could get the police to pick you up and bring you into hospital to give you your insulin. And I could direct you to a level of care. So I might say you have to live in rest home level care, or I could demand that I could have public nurses come onto your property daily to watch you take your diabetes medicine. That is essentially what mental health legislation allows us to do, but for people with a mental disorder, not people with diabetes. And if you think through those comparisons, it might help you to think about some of the potential problems that there might be with mental health legislation, as well as helping you to reflect a little bit on some of your own perspectives of what it means to have a mental illness. All right, so just very quickly, let's look at some other acts. So the Criminal Justice Act, really what this does is this used to provide some determinations about what happens if you commit a crime with a mental illness that now come under the Mentally Disordered Act. Which is this act here. It came in 2011 because there was this recognition that there were some problems, right? And this really is looking at reasons why it might not be reasonable for you to be considered appropriate to stand trial. So you may be acquitted on the grounds of insanity. You may not be considered fit to stand. And all of these means you end up in a forensic hospital. And forensic hospitals in New Zealand are partly under the jurisdiction of the Ministry of Health and partly under the jurisdiction of the Ministry of Justice. And within those are what we call special or restricted patients. These are patients for whom whatever has occurred to bring them to the attention of mental health services is particularly severe. And so special patients have a whole extra layer of kind of safeguards about the freedoms of their movements. I'm not a forensic psychiatrist and I don't know what the case is in New Zealand, but certainly in the UK where I trained, many people who had been involved in crimes would not want to go down this sort of a route, largely because they would be detained for significantly longer in a mental hospital than if they were convicted and went to jail. But I'm not sure if that's also the case in New Zealand. What the Mental Health Act has as a specific exclusion is intellectual disability. And so what this act does, it allows treatment, but it only allows treatment for intellectual disability if there has been an offence. And you can see that this is kind of potentially problematic. So I've had the personal experience of looking after a patient with a significant intellectual disability who has committed an offence for whom we have worked very hard with police to have them prosecute, because only by having them prosecuted for the offence could we engage the appropriate level of care nationally for them. Now you can see there seems to be something really wrong with needing to do that. And so although these acts are written with the best intentions in mind, sometimes how they actually play out in real life can be quite different, and that can be quite problematic. But essentially what this act does is it prevents people with intellectual disability, severe intellectual disability, from going to jail, and provides a different avenue of care and treatment for them. And then finally, the triple PRA. And I think the triple PRA is important because you're going to need to be thinking about how this works in terms of many of the patients you see. So in most areas of medicine, our patients are elderly and often start to have cognitive problems. Those cognitive problems are often considered to be likely permanent. And because they're likely permanent, it's likely that you're going to need some form of support for patients over time in terms of making choices. So essentially what this does is it allows the court to appoint someone to be a substitute decision maker. So they are provided this thing, power of attorney, and they make decisions. And those can be in two groups. So for health or for personal rights and property, so they're distinct and different. Sometimes people are EPAs, enduring power of attorneys, for both, or sometimes for one or other. So for example, I am an EPA for a couple of my relatives for health, but not for personal rights and property. And that makes good sense. So I know them very well. I understand medicine reasonably well. I'm likely to be in a position where I can have a pretty good idea of what they are likely to want in the event that they find themselves in a position where they're unable to provide that kind of information. And it is likely, as time goes by, that many of you will be asked by family or friends to be in that sort of position, either for an elderly person who cannot make those choices, or, as is my case, in advance. So these are advance directives. So should that happen, then this becomes activated. So it's really interesting to note here that the triple PRA, which is an act that allows for substitute decision making, is entirely based on capacity choices. That's it. You lose capacity, you can get it replaced. Unlike the Mental Health Act, which has nothing about capacity in it at all. And so it's interesting to note they're quite different in terms of what they are looking to do. And that's me. I'm done. I don't have any other slides. So what I'd encourage you to do is to think closely about this, try and think about what this means in terms of your practice. And like I said before, if you've got any questions or queries, I'm pretty easy to find me, at otago.ac.nz, my name, and I'd be happy to answer any other questions. So thank you for your time.